This narrated PowerPoint is about the right to privacy, and it is a really important part of constitutional rights and liberties, but it's also very controversial. It's controversial for a couple of reasons. One, the right to privacy involves really important issues about who people can have relationships with, about what kind of medical care people can seek out, even questions about whether or not a person has a right to terminate their life if they do not wish to be alive again. The right to privacy, issues surrounding privacy, are oftentimes related to life and death, and they're also related to things that are really, really important to people's lives, like marriage and procreation, that kind of thing. And so it's a really important issue for that reason, but it's also important for another reason. Most of what we study this semester are things that are specifically put in the Constitution as rights, right? So we talked about freedom of religion and free speech. Both of those are in the Constitution as protected rights, but the right to privacy is not. So what we're going to do is we're going to talk about how the issues that we tend to think of as issues that are related to privacy were decided by the court prior to the court finding or discovering a right to privacy in 1965 in a case called Griswold versus Connecticut. And we'll talk a little bit about Griswold, and then we'll talk a little bit in this PowerPoint about the kinds of cases that have come to the court since Griswold versus Connecticut, in particular, the decision in 1973 that the constitutional right to privacy extends to a woman's decision to terminate a pregnancy, that decision, Roe versus Wade. So that's where this PowerPoint is going. So let's talk a little bit about how the court approached the question of under what circumstances, under what conditions can the government, or is the government violating a person's rights, not necessarily privacy rights, but their rights that are in the Constitution, and under what circumstances is it legitimate for the government to impose itself on somebody's liberty interests. So by liberty interests, what I'm talking about are interests that are referenced in the Constitution itself. So there are three places in particular where the Constitution references not a stated right to privacy, but a recognition that people have individual autonomy that has to be respected by the government, that we have a right to go about our lives without interference from the government unless the government can demonstrate a pretty compelling interest in interfering with our liberty. So the Fourth Amendment, which we're going to actually study in the last part of the semester, the Fourth Amendment is where you find the right against unreasonable search and seizure. So it specifically says that people have a right to be secure in their persons and their effects and their papers against unreasonable search and seizure, and that there are conditions under which the government can interfere with that right. But the Fourth Amendment deals with, in particular, when the court would be required to have a warrant to come into your house or to search your person or to search through your effects, your computer or your papers or whatever. The Fifth Amendment and the 14th Amendment reference liberty specifically. So both the Fifth Amendment and the 14th Amendment include a clause which is generally referred to as a due process clause. And what the amendments say is that no person can be deprived of their life, liberty, or property without due process of law. And what that's intended to do is to limit the power of the government to interfere with the decisions that people make about how they're going to structure and carry out their lives, what's important to them, who they want to, in the cases that we're going to talk about, who who they want to marry, who they want to form relationships with, whether or not they want to have children, etc. Those are really important questions, and they come up before Griswold versus Connecticut in 1965, but the court dealt with them mostly by talking about the liberty interest in the Fifth and 14th Amendment. So the issue of privacy and the issue of protecting people's individual liberty are very closely interconnected. It's hard post Griswold to sometimes tease out what's a privacy issue versus a liberty issue. So we'll talk about that when we talk about some of these cases. But I'll give you an example of a case that came up long time ago, over 100 years ago, where the court had to decide whether or not a person's liberty interest could be violated by requiring them to subject themselves to a medical procedure that they didn't want to subject themselves to. So this was decided in 1891. So Clara Botsford was on a train, and in the course of her railway journey, she was injured when the sleeping berth above her fell down, and it conked her on the head, and she sustained some pretty serious injuries and sued the Union Pacific Railway. I think she sued for like $10,000. So right before the trial started, the railway requested that the court demand that Clara Botsford subject herself to a surgical examination by the railway's doctor. And of course, Clara Botsford objected. She said she did not wish to have her body examined by a person without her consent, and that it should not be a condition of her being able to sue the railway for damages if she could prove to a jury that she had suffered those injuries. And the railway said that they should be allowed to gather evidence for their side by forcing her to subject to a surgical examination. And the court sided with Botsford and said that that in fact was too great an invasion. That would be too great an invasion of her person. She had a liberty interest in her personhood and her physical, keeping her physical body out of the hands of people she did not want her physical body to go into. So that was one example. The other thing that happened before Griswold is actually something that happened in a dissenting opinion. So there's a case that came before the court called Olmsted versus the United States. It came to the court in 1928, and it involved the Fourth Amendment. The Fourth Amendment, which says no unreasonable search and seizure. And the question was whether or not Olmsted's Fourth Amendment rights were violated when the United States government got permission from the phone company to tap his phone line. Olmsted argued that his person included his conversations and the way he went about his life, and in the privacy of his own home, when he made phone calls, the argument was that the government should have to get a warrant to eavesdrop on his conversations. Obviously, they couldn't eavesdrop, just listen to his conversations because he was in the privacy of his own home. The U.S. government argued that the phone line itself wasn't owned by Olmsted, and so they didn't have to get a warrant to tap into his phone, and the U.S. government won. So Olmsted lost his case. But Brandeis wrote a dissent, and what Brandeis said in his dissent eventually makes its way into being the prevailing opinion about what it means to protect people's liberty interest to be left alone unless the government goes through the proper channels and provides due process and that kind of thing. And this is what this is what Brandeis wrote. I'll read it to you, but I'll also show it to you. Back just a tiny little bit. The makers of our Constitution undertook to secure conditions favorable to the pursuit of happiness. They recognized the significance of man's spiritual nature, of his feelings, and of his intellect. They sought to protect Americans in their beliefs, their thoughts, their emotions, and their sensations. They conferred against the government the right to be let alone, the most comprehensive of rights, and the right most valued by civilized men. Now, this is in dissent, but it's a ringing endorsement of this sort of concept of privacy, that there's something fundamentally important to personhood, to be left alone to pursue your interests, etc., unless you're harming somebody else or unless the government has a legitimate interest in in interfering with your right to be left alone. So that's a dissent, but it's a really important. So a lot of the cases that come to the court having to do with liberty interests involve um, things like vaccination requirements, kind of physical intrusions into people's lives, and also the way people raise their children. And so matters of family life. And so some of the early cases are really interesting cases of where does your liberty interest end and where does the state's interest prevail. And in a lot of these cases, the court sided with the individual's liberty interests. And I'll give you one very horrible example of when they didn't. So the exception that sort of proves the rule. So I'll give you some example cases. So for example, in Jacobson versus Massachusetts is one example. The second case I want to talk a little bit about is called Buck versus Bell. And then the third case I want to talk about is Skinner versus Oklahoma. This is a picture of Carrie Buck from the 1920s. So in Jacobson versus Massachusetts, the issue came up, and I give you this case as it's actually sort of coming up again in our politics. Jacobson versus Massachusetts involved the state of Massachusetts requirement that all of its citizens be vaccinated against smallpox. And Jacobson objected. He said, I have a liberty interest in keeping my body from being subjected to a vaccination. The state of Massachusetts argued that any liberty interest that Jacobson has is overridden by the state of Massachusetts's significant interest in public health. And smallpox obviously is a very deadly disease. In 1905, the Supreme Court sided with Massachusetts. They argued that yes, Jacobson has a liberty interest, but it's not absolute. And as long as the government can demonstrate a significant public health necessity, that sort of overrides the liberty interest or justifies an intrusion into Jacobson's liberty. Similarly, a case came before the court called Buck versus Bell in 1927. This is generally regarded as a pretty horrible Supreme Court decision, but it goes to show you that before the court recognized a right to privacy, some of these liberty interest cases depended on, a person's liberty depended on who sat on the court. And in this case, some other arguments that were going on in the country around eugenics and what kinds of people should be allowed to reproduce and what sorts of people should not be allowed to reproduce, and under what conditions the government could deny a person the opportunity to have children. Carrie Buck was institutionalized. So she was essentially a ward of the state. So she was in a state institution. Some people historically have argued that she was put in an institution to keep her because her family was embarrassed by her. But nonetheless, she was in 1927 sterilized by the government. The government made the argument that she was the feeble-minded offspring of a feeble-minded woman, and if she were allowed to procreate, she would likely produce feeble-minded children who would then become a burden on the state. And the state argued that they had a legitimate financial interest in keeping people from procreating who might procreate people who would become a burden on the state. And in 1927, the Supreme Court sided with the state, and they argued that just as the government can require that you get a vaccination, the government has an interest in keeping people who are unfit to be parents from becoming parents. And again, by today's standards, that's a pretty horrible Supreme Court decision, which the court kind of, I don't know if it overturns Buck versus Bell, but certainly in 1942, the court goes in a different direction and articulates a more modern interpretation of the liberty interest people have in making decisions on their own about whether and when to procreate. In this case, Skinner versus Oklahoma. Oklahoma had a law that allowed the government to sterilize people who had been convicted multiple times of certain kinds of crimes, so habitual criminals. And the argument was that somebody who was a habitual criminal did not have the sort of moral compass necessary to raise children and should not be allowed to procreate and pass on their sort of immoral life view to future generations who would then, again, with the logic of Buck versus Bell, become a burden on the state or perhaps incarcerated themselves, etc. But in 1942, the Supreme Court disagreed with that argument, and they sided with Skinner and argued that the decision to procreate is an intensely personal decision that is deeply rooted in the liberty interest that people have and the right that people have, the liberty interest as a right in the Fifth Amendment, and in this case in the 14th Amendment, because it was the state of Oklahoma that wanted to sterilize Mr. Skinner. And so these are some early cases, pre-right to privacy, where the court had to sort of grapple with this question: what sorts of arguments should the state be allowed to make against a person's liberty interest in something as fundamentally personal as a decision to have a child or to start a family? Other issues that came up before Roe versus Wade involved other aspects of family life. And these are two really famous cases, Meyer versus Nebraska and Pierce versus Society of Sisters. And they came about, so these are sort of just past World War I, where we had fought with Germany, and also at a time when there was a lot of anti-Catholic sentiment in the country. And so sometimes governments want to use their power to impose a particular standard on people based on what are the prevailing majority opinions at the time. And so these cases illustrate those kinds of political environmental pressures that can be put on individual, that can affect individual liberty. Meyer versus Nebraska involved a law in Nebraska that prohibited people from teaching German as a foreign language. It prohibited the teaching of German to children until they were older. So young children could not be taught German. And so that the idea was that we had fought a war against Germany. We didn't want German culture to be, children to be exposed to German culture or German ideas. And so we would have a law that says you can't teach kids how to speak German. And what was argued was that interfered with people's liberty interest in making a living teaching German, or families who want their children to learn a foreign language, want their children to be exposed to different languages and be allowed to take a foreign language or be taught a foreign language. And in 1923, the Supreme Court sided with Meyer, and they struck down the law. And they said that the government's interest is not a good enough, the government doesn't have a good enough reason to stop people from learning how to speak German or from making a living teaching children how to speak German. And similarly, they made a similar kind of decision in Pierce versus Society of Sisters. So this case involved a law that prohibited parents from sending their children to parochial schools, to private religious schools. Most private religious schools then and probably now were Catholic. And so this law was motivated by anti-Catholic sentiment. And families who wanted to send their children to private Catholic schools, and also groups like the Society of Sisters who ran private Catholic schools, took the state to court, arguing that the state, for no good reason other than animus against Catholics, which is not a good enough reason, right? Religious prejudice is not typically seen as a good enough reason for the government to pass a law. What they argued was that the government was interfering with their liberty interest, not only in making a living or running a school and offering their services to people who would be willing to pay to have their children educated there, but that it also interfered with the fundamental right of the parent to raise their children as they saw fit. But that does not mean that parents have a right to abuse their children or beat them to death or anything like that. But fundamental decisions about how they raise their children, the court said, are not really the government's business. So there are some early cases where the court recognizes that these decisions are really, really important to the structure of the family, to the ability of people to exercise their liberty interest in setting up their lives and their families in ways that are most likely to provide them with happiness and with senses of well-being, etc. So we're going to fast forward a little bit, and we'll talk about Griswold versus Connecticut and where the right to privacy came about. So we call the right to privacy a court-created right because it's not specifically listed in the Constitution, and the court actually found the right in a series of decisions or in a court decision. But it's not the only one. So I'll give you both of the sort of court-created rights that are pretty important these days. The first is a case from Lochner called Lochner versus New York that was decided in 1905 that established the constitutional right to contract. So I give you this because it's often argued that it is liberals who read new rights into the Constitution and conservatives who don't want the court to create new rights, but to allow those rights to be created by legislative bodies or by citizens amending, say, their state constitution, etc. But Lochner versus New York is the opposite because the state of New York had a law on the books that said that it was illegal for anybody to work more than 60 hours a week. I don't know if it was specific to certain kinds of industries, but the industry that is at issue in Lochner was a bakery. And what New York argued that they had good reasons for that, and if people are too tired because they've been working too hard, they will possibly get injured, and that the state has an interest in regulating commerce in this way and in regulating the economy in this way. And the court disagreed. In 1905, the court struck that law down, and they said that even though it's not specifically mentioned in the Constitution, the liberty interest that people have in ordering their lives and making decisions about how they make a living and how they spend their time, etc., is enough to establish a right to contract. The person has a right to offer to pay somebody for doing work, and the person has a right to accept that offer of work, and it's really no business of the state to interfere in that. Now, since 1905, the jurisprudence has changed somewhat, and we do allow the government to require people to be paid overtime, et cetera, and we have worker safety laws and we have child labor laws and all of that. But in 1905, in this sort of basic case, Lochner versus New York, the court created said that the Constitution, through its various provisions about liberty and not allowing the government to interfere with liberty without due process of law, et cetera, is broad enough to encompass a right to contract. So even though Griswold versus Connecticut, which was decided in 1965, is significantly more controversial than Lochner versus New York, it's not the first time the court has created a right. But in 1965, the court created a right to privacy, which has been controversial ever since. And I've asked you to watch a bunch of videos about Griswold versus Connecticut, and those videos talk about cases that have come after Griswold and about the importance of Griswold. So I'll touch on this now, and then we'll talk about some of the cases. But essentially, what Griswold involved was a case, a law. Griswold was a doctor who worked in a family planning clinic and provided birth control to women seeking birth control. But the state of Connecticut passed a law banning the use of contraception by married couples. It was the only law in the land. It was the only state. Connecticut was the only state that had such a law. But what the state argued was that they had an interest. The state had a legitimate interest in stopping people from straying from the marriage bed and being adulterous. And the argument, I'm obviously paraphrasing the argument, but the argument was that if women couldn't have extramarital sex without the possibility of getting pregnant, they'd be less likely to stray. Similarly, if a man didn't know whether he would impregnate a woman or not, then he might not stray. But by allowing people to use birth control, they would facilitate immorality by married couples. So Griswold intentionally broke the law and gave contraception, allowed people to be prescribed contraception, and was arrested. And that's how this case comes to the United States Supreme Court. And in 1965, the Supreme Court struck the Connecticut law down. And essentially what they argued was that the Constitution itself does not say that there's a right to privacy. But if you look at the various provisions in the Constitution, they cast a glow or a shadow, or they have a reach that goes beyond just the plain meaning of the words to encompass a right to privacy. It's known as penumbra theory. Penumbra is this shadow or halo emanating from something. My dog is barking. Hopefully he stopped, but we'll see. So for example, the First Amendment says we have a right to freedom of association, which implies that we have a right to be friends with the people we want to be friends with and refuse to associate with people we don't want to be associated with. The Second Amendment says we can't be forced to quarter soldiers in our homes during peacetime, which implies that our home is a private sphere that is not something that is the government's to use whenever they want. Of course, the Fourth Amendment says we have a right to be secure in our homes and in our persons from unreasonable search and seizure by the government. The argument there is that there's a zone of privacy around you and your stuff that is yours, and the government can't just interfere with that for no good reason. Of course, the Fifth and 14th Amendments say that we have a right to liberty, and the government must give us due process of law before they can infringe on that liberty. And then if you look at the Ninth Amendment to the Constitution, the Ninth Amendment, which is part of the Bill of Rights, is basically a catch-all. It says, we wrote down all of these rights in the first 8 amendments to the Constitution, but we recognize that there might be other rights that are out there. And we're not saying these are the only rights you have. We're just saying that these are the rights we're going to put in the Bill of Rights. So the Ninth Amendment implies that there could be rights that people have, regardless of whether the Constitution specifically says they have those rights. So in 1965, the Supreme Court ruled that one such right, implied but not specifically mentioned in the Constitution, is the right to privacy. And so after 1965, you can look at some pretty important cases that came before the court where this right to privacy was used to protect the rights of people to make personal, private decisions about the kinds of relationships they want to have with other people and the kinds of things they want to do with their bodies, etc. So I'll give you a few examples just to give you an idea of how that plays out in the courts. This is a picture of the Loving family. The Loving family was the subject of a Supreme Court case in 1967 called Loving versus Virginia, where the Supreme Court extended the right to privacy not only to include decisions about using birth control or when and how a married couple will start their family, but also decisions about who a person could actually get married to. The state of Virginia and several other states at the time had laws on the books that prohibited interracial marriage. The state's argument was that they had a legitimate interest in promoting racial purity, especially the purity of the white race, and that gave them the authority to interfere with the decision of the Loving couple to stay married. They got married. They were told they would have to leave Virginia if they wanted to stay married. There's actually a really good movie that just recently came out about this court case. In 1967, the Supreme Court ruled that the right to privacy extends to decisions about who a person wants to form a family with. And they struck down Virginia's law and said that any state law that prohibits interracial marriage would be unconstitutional not only under privacy, but also under the Equal Protection Clause and the Due Process Clause of the 14th Amendment. This case we already talked about when we talked about pornography. The court ruled in 1969 that the private enjoyment of pornography in the privacy of one's home, not child pornography, but pornography involving adults, is also protected under the right to privacy, and the government has no business poking its nose into the entertainment choices of people in the privacy of their own home. So these decisions were post-Griswold privacy cases, but the biggest case and probably the most controversial application of Griswold versus Connecticut has to do with the right of a woman to have an abortion. And that is a controversial decision to this very day. If you watched any of the Supreme Court nomination hearings of Amy Coney Barrett or read articles about them, you'll know that a lot of the discussion surrounding her nomination is about whether or not she will not only vote to overturn the Affordable Care Act, but whether she will become a vote on the court to overturn the Supreme Court decision from 1973 called Roe versus Wade. So there's a lot that we could do to talk about abortion rights. I'm going to try and sort of summarize this issue as succinctly as I can in this PowerPoint. So in 1973, the Supreme Court ruled that at least in the first part of a pregnancy, the first 3 months or so of a pregnancy, a woman's right to privacy outweighs any interest the state might have in stopping a woman from getting an abortion. So Roe versus Wade is important because it establishes that there is a constitutional privacy right that women have to have an abortion, at least in the early part of their pregnancy. As the court has become more and more conservative, there have been efforts by state governments to restrict abortion rights, and then pro-choice groups fight those restrictive laws in the courts. And there have been many, many cases that have come before the court which have challenged, not only challenged Roe versus Wade, have asked the court to overturn Roe versus Wade, which the court has never done, but also asked the court to determine under what conditions the state can ban abortions, or what restrictions on abortion services could the state constitutionally put on women without violating the fundamental principle of Roe versus Wade. So I don't want to talk about 50,000 abortion cases, but I do want to talk about some of the most important ones. I'll give them to you. And if you're taking notes, you can take notes. We'll talk about Planned Parenthood versus Casey, Gonzalez versus Carhart, and Whole Woman's Health versus Hellerstadt. These three cases are illustrative of the kinds of cases that have come before the court. So I'll talk a little bit about those cases, and then also talk about some very specific things that the court has said states can do to restrict abortion, and some of the things the court has ruled the states cannot do to restrict an abortion. So Planned Parenthood versus Casey is a really important case because, one, it upheld some restrictions on abortions. I'll talk about those in a second. But the other reason Planned Parenthood versus Casey is a really important case is because it changed the framework for evaluating laws that restrict abortion. So Roe versus Wade had set up this sort of unscientific, really, and kind of unworkable standard that said in the first trimester of pregnancy, the state has virtually no interest. In the second trimester, the state's interest is greater. And then after viability, if the fetus could live outside the womb, that's when the state's interest is greatest. Planned Parenthood sort of changes that calculus and recognizes that at the beginning parts of a pregnancy, the woman's right is most strong, but it softens up the rest of the standard, and it says that it's not unconstitutional to restrict abortion services or to put conditions on receiving an abortion, as long as those restrictions do not amount to what the court calls an undue burden on the woman. This is a very controversial standard because it's up to the courts to decide what's an undue burden and what is not an undue burden. And if you have a liberal court, they're going to see more things as an undue burden. If you have a conservative court, they're going to see fewer things as an undue burden. And so the Planned Parenthood versus Casey is an important case because it establishes this sort of new standard for determining what the court will allow and what the court will not allow with regard to restrictions on abortion. And we'll talk about what some of those are. The other kind of case that has come before the court has to do with at what point can the government ban abortion altogether, right? So there are some states that would like to ban abortion altogether. Well, under Roe versus Wade and even under Planned Parenthood versus Casey, at this point, states can't do that. But generally, the court has looked favorably on laws that seek to restrict abortion after it can be determined that there's a likelihood that the fetus could survive outside the womb. And there hasn't really been a decision about exactly when that is, but what Gonzalez versus Carhart did, which was decided in 2007, is that it gave the federal government and state governments the authority, without violating the constitutional right to privacy, to ban what are called late-term abortions, or abortions that are performed at the very end of a pregnancy, very close to the end of a pregnancy. And what the court ruled in Gonzalez versus Carhart is that the government can ban abortions late in a pregnancy unless the mother is likely to die if she isn't able to have an abortion. So if it is in the interest of the woman's health, the state can ban the abortion, but the abortions that are necessary to save a woman's life are protected. So Gonzalez versus Carhart was very controversial when it was decided in 2007. It is it is controversial to this day. Whole Women's Health versus Hellerstedt is an example of a case where the kind of case that has been coming to the court sort of recently. This case came before the court in 2016. It was a law in Texas that required doctors performing abortions to have admitting privileges to a hospital, but it also said that any health center that provides abortion services has to meet certain standards that are very nearly the same as standards that would apply to a hospital. So the Whole Women's Health Center would have had to close because they didn't meet the parameters of the way the law was written. And what they argued was that since abortions are generally safe, and they are generally as safe as other medical procedures that the law does not require be done in a hospital-like setting, that by putting these requirements on women's health clinics, they would effectively be required to either spend tons and tons of money to unnecessarily bring their facilities up to the standards of the state, or they would have to shut down. And in 2016, the Supreme Court ruled that law, that Texas law, was an undue burden on women, that it was an unconstitutional undue burden on women. And the reason I bring this up is because this issue is sort of still being fought out in the courts. There's another case pending before the court this year, which would essentially do the exact same thing. And there's been some change on the court since 2016. And so states and pro-life organizations are hoping that the new majority on the court will overturn some of these laws. So where it stands right now are some of the things that have come before the court and what the court has ruled. So these are some restrictions on abortion that the court has said are constitutional, that states are allowed to put these restrictions on abortions. Banning the use of public facilities for abortions. Some states say you can't get an abortion at a public health facility. Viability tests before an abortion can be performed. The court has said if a state wants to put that requirement on, they can do that without it being an undue burden on a woman. Requiring women to wait 24 hours before they have an abortion once they've made the decision to have an abortion. Some states are sort of playing around with that. Well, if we can make people wait 24 hours, could we make them wait 72 hours? Could we make them wait a week? Could we make them wait 6 months? So this is very controversial as well. Requiring women be given informed consent forms so that they know what an abortion is and what the possible side effects might be. That's not all that controversial because most medical procedures require that you sign a consent form. What's controversial about these are what some people argue are coercive consent forms. So, for example, some states require that women undergo a sonogram, even if the doctor doesn't think it's medically necessary. And so some people think that some of those are not really informed consent requirements. They're coercive, so it's very controversial. Requiring that a minor get the consent of a parent before they can have an abortion. The court has said as long as there's a judicial bypass for that. So, for example, if a a girl thinks that she was impregnated by her father, she would be able to go to a judge. Or if a girl thinks that she would be in physical danger if her parents found out she was pregnant, she could go to a judge and ask a judge to provide the consent on behalf of the child. And bans on federal or state funding for abortions have also been upheld. So in 1977, in a case called Maher versus Roe, the court ruled that states may ban the use of Medicaid, of state funding for medical services. They said that the states could could prohibit any of the Medicaid funding to be used for abortions. And in fact, it is illegal under federal law for any federal money to be spent on abortions. And that's what's known as the Hyde Amendment. The federal government does not allow any federal funds to be used for abortion services. And the court has upheld all of these as not presenting an undue burden on a woman's right to choose. And on the other hand, there have been a few restrictions that have been found to be unconstitutional or to present an undue burden. One, requiring abortions to be performed in hospitals. The court said that would present an undue burden because because abortions are generally safe, and so there's not a real government interest there's not a health interest in requiring abortions to be performed in hospitals. And it would mean that some women would have to travel great distances to be able to access the services because they don't live near where there's a hospital that would be willing to perform an abortion. In some states, there wouldn't be any abortion services available at all. Making records public, there was a law in one state that would have made it available to the public who had an abortion, and the court ruled that we don't generally allow the publication of people's medical records, and so there would be no purpose served in invading a person's general right to have their medical records be private. And then there was a law that was struck down that would have required women to inform their husband if they decided to have an abortion, and the court struck that down as an undue burden, especially if a woman's could be in physical danger if she told her husband that she was pregnant. The court struck that down. And so the right to an abortion, the constitutional right to access abortion services, is quite controversial to this day. There are some states that have laws on the books that are they're not in place, but they're ready to go, so that if the Supreme Court overturns Roe versus Wade, then their state would already have a law on the books that would get triggered and would go into effect that would prohibit any abortions in the state. Some states have also recently passed abortion restrictions as early as 20 weeks or 21 weeks into a pregnancy, and so that would test the court's ruling that abortions can be prohibited after viability. So it's still super, super controversial. Anyway, other issues that have come up under the right to privacy that are really important too, and a lot of those issues involve LGBTQ issues about interpersonal relationships and sexual relationships, and of course the decision about whether or not same-sex couples have a constitutional right to marry. These aren't specifically only privacy cases. They also involve the 5th and 14th Amendments right to due process, but everything post-Griswold is sort of interconnected with these liberty interest questions. So we can talk about these here. We'll reference these again when we talk about civil rights in the next week's material that we're going to be covering. So there's two cases that are super, super important having to do with LGBTQ issues, and that is Lawrence versus Texas, which was decided in 2003, and the 2015 decision called Obergefell versus Hodges. Lawrence versus Texas involved a Texas state law that criminalized same-sex sex acts. So in the privacy of one's own home, it was illegal for same-sex couples to engage in certain kinds of sexual activity, even though mixed-sex couples could engage in that kind of sexual activity without it being against the law. And in 2003, the Supreme Court struck that law down. I think there were similar laws in something like 13 other states that got struck down at the same time. And essentially what the court ruled in Lawrence versus Texas is that Texas was imposing its moral code on something that was so deeply personal and so deeply connected to a person's happiness, to a person's sense of self, and a person's right to structure their lives and their associations and their relationships in a way that was designed to fulfill themselves as a human being, that Texas had little to no interest in regulating that kind of behavior. Texas had made the argument that they had a right to regulate anything they wanted to if it was with regard to morals. So it's an interesting case. Texas said that if they really wanted to, they could ban card playing or dancing if they thought people shouldn't be able to do those kinds of things. But in Lawrence versus Texas, the Supreme Court ruled that states have no legitimate interest other than the illegitimate interest of not approving of homosexual relationships, but that they don't have the right to use the power of the government to restrict those kinds of behaviors. And then, of course, most people are aware, in 2015, the Supreme Court ruled that all of these previous cases related to the importance of marriage in family decisions and in stabilizing society and in fulfilling people's individual happiness, etc., that those decisions also give same-sex couples a constitutional right to marry. Mostly the court ruled that this was a question of equal protection of the law under the 14th Amendment, but there's a lot of reference of the general sort of right to privacy, to be left alone, to organize and order a person's life in the way they saw fit. So this map just shows you that the country was already moving in the direction of Obergefell versus Hodges in many ways. Most states had already moved in the direction of making it legal for same-sex couples to get married, but there were a significant number of states in which it was not legal for same-sex couples to get married before Obergefell versus Hodges. It remains to be seen. There are some people who argue that as the court has become more conservative, the decision in Obergefell versus Hodges may be revisited by the court at some point, and then the court would have to rule on whether or not Obergefell versus Hodges was rightly decided or not. So these are really important decisions. These are really important cases that have a real impact on people's real lives. That's one of the reasons the issue of privacy is so important. So the last thing that I want to talk about, and I know that this PowerPoint is getting long, so I hope you've taken the time to stop it when you needed a little bit of a break. The last issue I want to talk about is one that comes up a lot when we talk about privacy, and it's a question: does the right to privacy extend to end-of-life decisions? Questions about physician-assisted suicide, or does the state have the authority to deny a person the right to terminate their life if they choose to do so? And essentially what the court has said is, no, you don't have a right to physician-assisted suicide. And this is one of those issues where the court has not said that there is a privacy issue in that. The court has said that you have a right to refuse medical care. The court has ruled So the court has ruled that a person, sorry, I had to stop for a second there because my dog was barking again. So the court has ruled that there is no constitutional right to physician-assisted suicide. People do have a right to refuse medical care, even if refusing medical care could lead them to die. But they don't have a right to the assistance of a medical professional in the decision to terminate their life. And there are a couple of cases where the court has made rulings here. So Cruzan versus Missouri Department of Health. This was a really big issue back in 1990 when all of this came up. Cruzan had been in a car accident, and she was in a sort of persistent vegetative state, what was called a persistent vegetative state. And her family wanted to intervene on her behalf and have her life support removed. She has since died. But Missouri wanted to keep the life support on. And they made the argument that because Cruzan had never indicated by what the court calls clear and convincing evidence that she would not want to be kept alive, the family could not intervene on her behalf. They could not make that life or death decision for her. What the family argued was that she had made her wishes clear. She had told her husband, she had told her friends, she had told her family, if I'm ever in a position like this, take out the life support and let me die. But Missouri said she had never written it down. There was no evidence of that. And they said, how do we know that people won't just say those things so they can get an inheritance? Oh, she wouldn't have wanted to live like this because they want her money or something. And so they said, we have an interest in keeping people alive unless they have shown by clear and convincing evidence, and that usually means a legal form that you have filled out. And the Supreme Court ruled in 1990 that the state can require clear and convincing evidence, that they can have that as their standard. They don't have to. They could have a lower standard if they want to that would have allowed the parents to step in, but they don't have to. And after 1990, that's when a lot of people really began doing not just wills, but also putting in their legal papers what should happen to them if they are in a position where they can't make that life and death decision. What would they want to do? Do not resuscitate, or hey, keep me alive by all means necessary. Those kinds of directives, medical directives, are much more common now, so that there is clear and convincing evidence when such a tragic event happens. In Washington versus Glucksberg, the Supreme Court made a sort of more definitive ruling that there is no constitutional right to physician-assisted suicide. Washington versus Glucksberg involved a group of physicians who were interested in and willing to participate in physician-assisted suicide, but the state of Washington at the time said no, it's not allowed in our state. And so they made the case came to the Supreme Court, and in 1997, the Supreme Court said states are not obligated to allow physician-assisted suicide. There is no constitutional right to physician-assisted suicide as part of the right to privacy. That's not a decision that a patient has a right to make with their doctor. I have a very good friend who died of lung cancer a couple of years ago, and she had always said if she was sick and it was incurable, that she would want physician-assisted suicide. And California now allows physician-assisted suicide, but Nina couldn't pass the medical exam. Her brain had been affected by the cancer, and since she had not written it down ahead of time, the doctors said they couldn't give her the medication that would have allowed her to die. So because she didn't meet the state's very strict requirements as to who who can get physician-assisted suicide. So since 1997, there are 8 states, including the state of California and Washington, D.C., which have laws on the books that specifically do allow physician-assisted suicide. But the court has not ruled that people have a privacy right in ending their life with physician-assisted suicide. So again, these are really important, very personal, very controversial, very emotional kinds of decisions that come up under the right to privacy. So I'm done. That's it. That's all I wanted to say.